Sarah Boone sidebars. We've already done a little bit of the Sarah Boone sidebars about a week and a half ago. If you guys haven't watched it yet, check out in the live stream. But I will put a video together for you guys if you guys want to take a look at it in the future. So we have all the sidebars together. So far in the Sarah Boone sidebars, we've covered the jury voir dire portion of it, which I just thought it was interesting to see reasons why a jury might be dismissed from being part of jury service. And it's kind of interesting to see, you know, the conversation happening behind the scenes, because I haven't really seen any of this before. Furthermore, we are reading more sidebar stuff as the trial is starting to begin in the Sarah Boone case. Now, Sarah Boone has already had her trial last year, 2024. I think it was in October that it started. Man, time flies. That's like more than half a year ago. Where we left off last time was the part where they were having a sidebar in regards to Brian Boone, Sarah Boone's ex-husband. Now, during this time, I think they were separated for a couple of years, and they had a marital agreement that Brian Boone was going to give child support and alimony to Sarah Boone, because Sarah Boone was not working. I don't think she was working at all. I think her full-time day job was just drinking and just hanging at the bars and getting into fights with people, but and doing arts and crafts. Can't forget about the arts and crafts now. So Sarah Boone, you know, wasn't working, but she did have partial custody of their son. And I think their son was, I forgot. Was the son maybe in middle school around this time? Maybe like around 11, 12 years old. I don't remember, but if you guys do, feel free to just drop it in the chat. But the part that they are in sidebar right now is where we're discussing Brian Boone and Mr. Owens, Sarah Boone's attorney, saying that, well, Brian Boone is considered an adverse witness and a hostile witness. Because remember, we're like, are they going to call Brian Boone to the stand? Is Brian Boone going to be able to testify? They didn't. We never got to hear from Brian Boone, which I think is okay. But we got to see his body cam footage, though, when he was talking about Sarah Boone and how he had to deal with her fights with her and George, and he would have to come over and like she would like summon him like he was like a fucking white knight or something like that. But Mr. Owens is saying that, you know, Brian Boone is a hostile, adverse witness because, well, Sarah Boone, she's been in custody for like 4.5 years and he hasn't been paying her alimony. And the state's like, well, you know, it's kind of understandable if someone's incarcerated why you wouldn't want to pay alimony or child support. Kind of weird, right? And so Mr. Owens is like, well, you know, that goes to his credibility, and then now we can use it to impeach him. And they weren't really sure whether or not they were going to call Brian Boone, so that was kind of like a pending thing. Ooh, got green here. I think green means interesting. Oh, we're going to be talking about the alimony. Moving to 22, family law case file, Boone v. Boone, case number 2017 DR 016600. I understand the state's objection as to relevance and hearsay. Response? Mr. Owens. Judge, Brian Boone, we anticipate, is going to testify for the state, may testify for the defense, and he may be considered an adverse witness or hostile witness. So we may attempt to establish either bias in his part based on some of the documents or orders in the court records, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders and that the reason being is because of his feelings for the defendant. Oh, what are those feelings? You know, he's got full custody of their son, and he has full custody for 4.5 years. That was not the agreement they originally had. And he was ordered to pay alimony, which he has failed to do so as a result of her being incarcerated. So, what did he really fail to pay? Did he really fail to pay alimony though? Is that a failure? I feel like when you say someone failed to do something, it means like they were supposed to do something and they didn't do it because they fucked up on their own. This is like he failed because Sarah Boone fucked up and she was being incarcerated. The phrasing here. Oh, man. So there's little litigation going on. Brian Boone has counsel. Sarah Boone does not have in that divorce, but the court. What does Mr. Owens, depending on what he says, the court, what does the non-payment of alimony have to do with what's happening in a family case? Mr. Owens, well, Judge, that goes to his testimony. That goes to his credibility. Whether or not he can be impeached, that her, in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for, he was supposed to pay $1,000 a month for a number of years, that he just failed to comply with the court's order, and that shows his personal bias or feelings towards Sarah Boone. The court response, Mr. J. It sounds like this is an ongoing pending litigation that has not been decided by a circuit court judge or the Ninth Circuit sitting in the family division. And I can't certainly understand why one of many believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated. and they probably wouldn't want to seek legal redress about those issues, and it sounds like it's all ongoing. The court. Are there any orders from the court in the case addressing the non-payment of alimony and that being contemptuous or in violation of any court order? Mr. Owens, no, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then wait, where is Gainesville? Is it Gainesville, Florida? How far is Gainesville, Florida from Orange County, Florida? Does anyone know? And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up that she's not represented. I don't represent her. I don't know, Mr. Owens, do you want to represent her? Do it. The court. Is there, so if there's no order in the court file, finding there's a violation of an order to pay alimony, what is, Mr. Owens? Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so I can get on to cross-examination. Gets cut off. The court. But it sounds like there's a pending litigation, including a relocation and I don't know because that's not my case and I haven't looked at it. Mr. Owens, that's been decided. That's been decided. He's been able to relocate. I don't know all the ramifications. I'll look at the clerk file. Think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know. The court. Can you all approach just for a moment? All right, now we're at the bench. I was on the family bench for 4.5 years. Here's my concern. I don't know the status of this litigation, and if there's a pending supplemental petition and he's arguing a substantial change in circumstances regarding alimony, there's not a requirement for him to pay for it. It's not contemptuous. Mr. Owens, yeah, I don't think that's the case. I don't believe that's the case. Okay, Mr. Owens. The court. There's not a pending supplemental petition. How did he move to Gainesville? The only way he can do it is with a supplemental petition. Mr. Owens. The supplemental petition didn't have anything to do with the alimony. It just had him, he wanted to move the child to Gainesville. And I know the judge granted that order because he was living in Gainesville. So he got the permission from the court, but I don't believe there was any pleading filed about staying his alimony payments while she was in jail. But I'll look at the file. All right. The court. I need clarification on that because I'm worried that there's other legal issues in the family law realm that are going to be at play for the non-payment of his alimony. Oh, northern Florida, but a couple hours, maybe 2 hours. Okay, Gainesville. Not familiar with Gainesville. I've driven through Florida before, but yeah. How dare you not pay her alimony when she's in jail playing silly buggers for 5 years? Happy Friday. Hello. Hi, Storm. How are you doing today? Mr. Owens. I think I would proffer that to the court if I was going to attempt to impeach him. Mr. Owens. On a topic related to his family law matter, Sarah's family law matter, I would proffer that testimony outside the presence of the jury for the court to make a ruling. The court. Okay. Mr. Owens. I don't know at this stage what he's going to say, but I think it's fair game on cross-examination to share his bias against Sarah Boone. He doesn't want Sarah Boone to have a contact with their son, Lucas. He says derogatory things to the son about Sarah Boone, and those are all fair game because he's fighting for full custody of the child or wants full custody. He never wants Sarah. He wants Sarah to spend the rest of her life in prison. This is Brian Boone. I think he's going to admit this on the stand that he wants Sarah Boone to spend the rest of her life in prison and he wants Lucas to have no contact with his natural mother. Any response, Mr. J? Mr. J. I reviewed the family court file and I don't see anything contemptuous about what he's doing based on these court records, not based on my understanding of family law, which was taking a class in 1995. Ooh, 1995. I do want to put on some caution into their sails, believe it's going to be completely fair game for him to say, I'm choosing to take these actions because she's incarcerated. We've taken great steps to avoid them knowing that. Oh, by the way, they didn't want the jury to know that Sarah Boone's currently incarcerated. However, Sarah Boone brings it up during her direct examination. Oh, man. And they're like, why did she say that? We're trying to keep that out. Oh, Sarah. We've taken great steps to avoid them knowing that. And besides the fact that she never comes in and out for jury selection. Oh, wait, did I? Okay, never mind. So I think it's going to be fair game for him to say, yeah, I'm not paying child support because she's in jail. Yeah, I'm not paying alimony because she's in jail. And I think that's either been settled based on the court file in the family court case, and it's still pending. I think that's fair game. And then also there's going to be the prior consistent statement that he made to rebut this recent motivation for fabrication. So we'll be prepared to introduce these prior consistent statements as well. Mr. Owens, Judge, and I realize I may open the door about that type of testimony. I don't know how to do the Florida Mr. Owens accent. Okay, I forgot there's like a small town that Mr. Owens is from. Oh, probably getting all fudged up. The court. Have you had a conversation with your client about the ramification of that? Mr. Owens, of the jury knowing that she's in custody? The court. Yeah. No, but I will, Judge. And like I said, I don't anticipate Brian Boone testifying until the first week of trial. Mr. J. And also, Mr. Owens again. Tony Henderson and I have 4-hour appointment with, of course, we haven't been able to talk to her much because of all that's going on this week, but Tony Henderson and I are going out to see her Saturday from 11 to 4 or 11 to 3, and then Sunday from 11 to 3. So we're going to spend, 8 hours with her this weekend. So we'll go over this as well as, gets cut off, Mr. J. There will also now be tablet messaging between Brian Boone and Sarah Boone that will become relevant if we go down this route, and jail calls between the two of them. Oh, wait, has anyone? Oh, Milton, Florida. Yes, Milton, yes. I think Milton, Florida is like, a 2-hour drive to Orange County, Florida, if I remember. Jesus. Wait, guys, has anyone covered any jailhouse calls between Brian Boone and Sarah Boone? Or do we have tablet messaging? That'll be kind of interesting to look into. I don't know. There is, though. Mr. Owens. All right. Well, I just want those specifics. What exactly you all are utilizing, but the court. I think that's an if. Then what happens? I mean, it's all going to be predicated on what he may say from prior consistent statement respective. Oh, Tanika got all the messages. Oh, okay. Tanika's 2 cents. Yeah, they're doing like extensive coverage for the Sarah Boone stuff and all the family court stuff as well. That'll be interesting to look at. Wait, what? 8 hours? Oh, geez. I thought Milton was only a 2-hour drive for Mr. Owens. Dang, 8 hours. Mr. J. And there's like a 5th GCA case, I believe, called State v. William that would suggest that we are not permitted by the court to be forced to tell people which particular pages we're going to introduce or which jail calls we're going to introduce, particularly when it's on rebuttal. This is all new to us that he was going to open all these can of worms, but we're just going to cautioning him that there's a potential rebuttal evidence on jail phone calls, tablets, prior consistent statements, and the testimony that will come out that the reason he stopped paying child support and alimony was because of her incarceration, which continues. Mr. Owen. I think the state believes Brian Boone is a key witness. I think they anticipated calling him. We believe he's biased and has animus towards Sarah Boone. The court. Okay, Mr. Owens, sorry. The court. No, that's fine. You can go ahead. Just the wheels are spinning in my head. Mr. Owens. You know, as it gets closer to his testimony, like I said, I think we should proffer whatever cross-examination. If I attempt to utilize anything from the domestic file, the family law file, that will be proffered outside the presence of a jury so the court can make a ruling. The court. Okay, I'm going to overrule the objection at this time. It may go to bias. Understand the hearsay concept, but if there's specific statements that may have been made, I just don't know at this point in time. So I think there's enough potentially there for some level of impeachment maybe, and that may be enough. So I'm going to overrule your objection for now. And I'm going to ask that before we can proceed from anything from the family law case on cross-examination regarding Mr. Boone, that, you ask to approach so that we can have a proffer and really dial it down to the point in time. Okay? Mr. Owens. Yes, sir. All right. What do we got here? So now we are at the bench. So we're about page 900. Total pages is, you guys can't see it, can you? Oh, you can't, but the total page is 2,529. Wait, should I zoom out for you guys? All right, y'all. So we are now at the bench, the court. Mr. Owens, have you had an opportunity to converse with Ms. Boone about the potential impeachments of her former husband and what answers may be elicited? Mr. Owens. Again, Mr. Owens is the attorney for Sarah Boone. We're also going to hear from Mr. Henderson and Mr. Beck as well. They are also defense attorneys for Sarah Boone. And then for the state, we have Mr. Cacciatore and Mr. J. All right, I hope I got it, everyone. Mr. Owens, my understanding is that potentially through my cross-examination of her husband, Brian Boone, as it relates to their dissolution of marriage file, that it may come out that she had been in custody for 4.5 years, and it may open the door to the fact. I have talked to her about that. I was going to talk to her about downstairs. Oh, hold on a second. Hold on. I remember they wanted to keep it out from the jury that she was in custody for 4.5 years, but she was the one who brought it up when she was testifying on the stand. And then they went into sidebar. They're like, yeah, we didn't expect her to say that. And then I think Mr. Owens like, yeah, I didn't expect her to say that either. But I don't know if it really matters to the jury she was in custody for 4.5 years. I don't know. Maybe that could be really biased and prejudicial. Okay. Okay, so custody for 4.5 years. They may open to the door to that fact. I have talked to her about that. I was going to talk to her about going downstairs and get confirmation unless you want me to spend about 5 minutes with her. The court. I'd rather do it now because I don't know where Mr. Boone's going to be in the state's case tomorrow, and I'd rather go ahead and do it now. Mr. Owens, I will. The court. You all can head back to the table. Thank you. So this document highlights funky because I don't know. It's the way the PDF is saved or something like that. I couldn't figure out how to get it so it doesn't highlight funny. But it just be like that sometimes. All right, let me go back. This one, yes. That's why it's all, I don't know, it's all blocky like that. I don't know why it's like this. Hey, Tuko, how are you doing today? We up in here. Hello, hello. How are you? The court. Yes, sir. Mr. Owens. While I was coming up the elevator this morning around 8 o'clock or so, I think there was 2 or 3 people going to different floors, but I pushed 12. There was already a couple of people in the elevator. When I got in there with my suitcase and whatnot, but there was a black officer that came in late as it was closing. Said hey to him. Said, you got a trial today? Said yes. Said Sarah Boone? He said yes. And I said, let's get this thing done. And he nodded. Within just a minute, we started going up and one of the females turned like this and I saw she had a juror badge on. The court, okay. Mr. Owens, brunette, I think she had a backpack. The court, okay. Mr. Owens, and so she heard that comment. The court, is it one of ours? Mr. Owens, yes, I believe so. The court, okay. Mr. Owens, there was no dialogue. There was just the statements I made. The officer just, the court, okay, well, I'll tell you what. Let's do this. Let's bring our jury panel in. And if it's not her, then there's no issue. If it is, we can approach and we can address it at the point in time. Does that work for everyone? Mr. Owens, I just felt like I needed to say it. The court, no, I appreciate your candor. Thank you. And if it is her, we'll approach. And maybe if we have to dialogue with her individually and if we have any impact, we can address it at the point in time. Okay, thank you. So at this point, I think they have already done opening statements. Maybe, I think trial's already started and the state is presenting. I believe so. The court. All right, we're at the bench again. Mr. James, or Mr. Owens. Mr. Owens, I don't believe she's in the group, but I'm not positive. Okay, all right. Mr. Owens, I don't know if you need to ask, was anybody with Mr. Owens during the elevator? The court, you want me to ask Mr. J? Mr. J, yeah, perhaps. Just a general question. Has everyone been able to follow the instructions? Stay away from this case. The court, sure, I could do that. Thank you. All right, this is the judge right now. Members of the jury, yesterday I told you that may happen to see a lawyer in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right. Juror in seat number 3 from my left, first row. Yes, ma'am. Juror number 3. I rode the elevator with the defendant's attorney. The court. Okay, thank you. Can you all approach forward just a moment? Mr. Owens, judge, and I think somebody else did too. The court. Oh, juror 4. I think it was pointing somewhere, I'm assuming. The court and juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Juror number 4. I think it was one of the lawyers. The court. Do you recall who specifically, sir? Juror number 4. I believe it was him. The court. Mr. Owens. Juror number 4. Yeah. The court. Okay, thank you. Now we're at the bench. Do you want me to remove the panel and inquire of them one by one as to what they heard and any impact? Mr. J. I think at most it'd be, should be those 2. And I'm deferring to the defendant. He's the one that brought this up. I have no concerns about what was said and overheard if it was hypothetically any of these people. Mr. Owens. I would just ask them if they would have any concerns that you would like to address privately. The court, sure. Mr. Owens, and if not, we'll proceed. The court, Do you want me to ask them individually or in a group setting? Mr. Owens, I say group setting. The court, okay, all right. Now we're in open court. All right, thank you both for your honesty. I appreciate that. Something we talked about earlier this week, and that's one thing that we will require and ask of you is just be open and honest. And I appreciate both of y'all openness and honesty. During riding the elevator, was there anything that you saw or observed that impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 3 says, no, sir. Juror number 4, left to right, first row. Juror number 4 says, no, sir. The court, all right, thank you. All right, with that, members of the jury, we're going to proceed with the opening statements of the morning. Oh, they haven't done opening statements yet. Okay, so this is the elevator right before opening statements. All right. I remember stuff like this happening. I just don't remember where in time it happened in regards to the trial. All right, so no issues here. We're at the bench right now. We have the court. Mr. J, how long do you anticipate your first witness being, sir? Do you guys remember who the first witness was in the Sarah Boone trial? Was it law enforcement or was it family member? No, I don't think the family members went until later on, right? The court says, Mr. J, how long do you anticipate your first witness being, sir? Oh, Mr. Cacciatore. I would say the court or Mr. Cacciatore. Good morning, Mr. Cacciatore. Yeah, good morning. Do you guys remember Mr. Cacciatore? He was the guy that was wearing... Every time we saw him, he looked like he was like a LA noir detective or something. I don't know. He was always like dressed kind of snazzy and like, was he wearing a hat or a trench coat or something like that? Hi, Northwest. How are you doing today? How's it going? During the elevator, cover the ears and scream, juror, 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 juror. There's a new family court filing. Brian objecting to all Sarah Boone's dumb filings. You haven't seen it yet. Does she have an attorney representing her or is she just doing all the filings herself? Does anyone know? Poor Brian Boone. We'll never get rid of the Sarah Boone. Oh, and also we read in the sidebars, apparently Brian Boone doesn't want their son to have anything to do with Sarah Boone, which makes sense. Really? She's also going pro se. Okay, I mean, she just having fun while she's being incarcerated, you know? Passing the time, passing the time. All right, Mr. Cacciatore, aka Mr. Trenchcoat. Yeah, good morning. Depending on the cross and how deep they want to get, I would say probably 20-ish minutes. The court. Okay, who is it? Mr. Cacciatore. It's Mr. Juan Torres. The court. Ah, the brother. The brother. Okay. Mr. Cacciatore. The other thing I would just bring to the court's attention, there's 2 other records custodians as well, one for the 911 call and for the Publix records. Again, Publix is a grocery store. Remember, there was like security footage of Sarah Boone and George going into the grocery store to buy like the Magnum bottles of the wine. I don't anticipate any of the cross on either of those witnesses. They're going to be like, I don't know, 5-minute witnesses. I was just hoping we could put them on before lunch. The court. Sure, that's fine. I think we could do that. Thank you. Yes, sir. Mr. J. I would ask that we enforce for local administrative order about addressing people by surnames and not just their first names. The court, please. Mr. Owens, tell me what I did. Mr. J. Well, you kept calling her Sarah. It's Miss Boone or Sarah Boone. The court, he's correct. There is a local decorum administrative order. Mr. Owens, all right, I know that George refers several times in the video, Sarah. The court, that's a different kitty because that's a different piece of evidence that's being admitted. But for the purpose of the parties or the lawyers referring to anyone, I ask that you use full names or surnames. It's appropriate in child cases to refer to the children as their first names, but not when we're dealing with adults. I actually have never heard that term before. That's a different kitty. Interesting. She can afford attorney court will give her family court, really? I don't know what's going on with her in the family court stuff. Hi, Kuya, how are you doing today? How's it going today? Yeah, she got life sentence, okay? Let her serve her life sentence. Yeah, I just know the family court stuff is just a mess because it's just her versus Brian Boone, and then she was asking for alimony, child support, and maybe even Pop-Tarts. I don't fucking know, okay? It's fucking Sarah Boone. I'm not surprised. Mr. Owens. Well, I meant to say Sarah Boone. The court. I understand, sir. I appreciate it. Thank you. Why did I label this orange? Man, when I read this about like 2 weeks ago. I don't remember what the color is. I think green means like pertaining to the trial stuff maybe, or orange is like maybe not important. I don't know. We'll see. The court. Can the parties approach momentarily? At the bench. State who might be your next witness. Mr. Cacciatore. Vincent Pataglia. Ah, bless you. He's a neighbor. I would anticipate his testimony. Oh, wait, I think someone in the court was sneezing and the court was probably saying, bless you. Remember how the judge had a habit of doing that? Anytime anyone would sneeze, he would stop what he was doing. He'd be like, bless you. Bless you over there. Vincent Battaglio. Okay, Mr. Cacciatore says he's a neighbor. I would anticipate his testimony could potentially be as long as Mr. Torres, or it could be longer depending on cross-examination and the issues the defense may choose to explore with him. The court, bless you. I'm on board with that because we got a later start. You know, if we got time to go into lunch for an hour a little bit, that's fine. Ballpark it for me. How long do you think? Like 20 to 30? Mr. Cacciatore, 20 to 30. The court, that's for direct and cross or just cross. Mr. Cacciatore, I think it's for direct and cross. The court, any reason to disagree, sir? Mr. Owens, I don't know. The court, I'm not asking you to hold yourself to it. Just, ballpark it. Mr. Owens, are you wanting to take a lunch at 12:30 or is that what you're shooting for? The court, yeah, that's fine. I could do that. I'm okay with that. Mr. Owens, we'll try to get there. The court, okay, excellent. All right, thank you. More bench stuff. Here's another bench. The court, I think now would be a good time stopping. It's 12:18. Mr. Cacciatore, yeah, it would be a good stopping time. The court, what do you say, gentlemen? 1:45 or 2? Mr. Owens, I would say 2, but if you could, Judge, yeah, we could ask for 2. But the other thing is, I've got a couple of experts. Dr. Harper is in Okaloosa County. Did I pronounce that right? Dr. Harper is in Okaloosa County. Dr. Brandon is in Miami. Just I know they probably know what they're all going to do. If they could just disclose something so I can get an idea, because both of them have to travel. One of them, Dr. Harper, gets cut off. The court is on trial call somewhere, as I recall. Mr. Owens, in Bay County, Panama City. So, Mr. Cacciatore, what do you want to know? Mr. Owens, we're not going to finish today? Mr. Cacciatore, no way we get done today. I think Monday late afternoon, we could potentially be looking at resting. If not, probably first thing Tuesday morning, The court, okay. Mr. Owens, well, that gives me an idea. Okay, Mr. Owens, do you plan on introducing any video, watching the 2-hour video today? Mr. Cacciatore, no, we won't do. Detective Kepsel will probably be Monday. Mr. Owens and the court both says okay. Mr. Owens, is a medical examiner testifying today? Mr. Cacciatore, I don't know if we would honestly get her to that point. We have her on standby for this afternoon, but it's going to depend. I can tell you that Brian Boone is probably the anticipated next witness, and I imagine he might be pretty lengthy for both sides. Oh, wait, so what Brian Boone did not testify, right? Is my memory messing up on me? He didn't testify, right? We didn't see Brian Boone? No Brian Boone at all? Oh my gosh, I don't think we saw Brian Boone. I wonder, why did they change their mind about Brian Boone? Hi, Christine. How are you doing today? It's good to see you. Hello. How's it going? He didn't testify, right? Hold on. Am I just having... Am I having an episode right now? Hi, Oahu. How are you doing today? Good morning, Corgi. Hello, Oahu. How's it going? He didn't, right? Or did he testify and it was really short? He did? What? Am I confused? What was he testifying about? No way. Did he testify? Oh, you're right. He did testify. It was so short that I think I felt like nothing really came out of it. It was so short that Corgi forgot, okay? It was so short, I forgot he testified. What did he testify about again? What did he talk about? Oh, was it just, oh, you know what? Now I remember why it would be relevant. Basically, I think her calling him that morning and he's like, excuse me, why haven't you called 911 yet? And then he was telling her to call 911 and then he finally arrives and she was panicking and he was like, nope, I'm not going inside that house. Okay, I remember that. Okay, yes. Because she didn't call 911. She called Brian Boone hoping that she, be rescued by him and that he would, I don't know, take over and deal with the mess, I guess. I forgot about that. All right, thank you. All right, so Brian Boone, they imagine was going to be lengthy. And then we also have CSI to do, also have Abraham Moreno to do, all of those. I thought potentially we may only get there or maybe 2, maybe 1 or 2 witnesses after that. Mr. Owens, okay, that helps, yeah. The court, okay, I appreciate it. Just a reminder, both of you all have done it. You refer to George Torres as George. You refer to another witness by the first name. I'm not going to call you out in front of everybody. Just please be mindful. Mr. Cacciatore, I apologize, Your Honor. The court, We could just continue for both sides to use those surnames. It's just an appropriate thing to do. I'm going to give the jury the same instruction I've given them, release them, and ask them to come back here 2 o'clock. I've got a question to ask of your client before we release her for lunch. Anything else we need to cover, gentlemen? Not from the state. No judge. At the bench again. The court says, yes, sir. Mr. Cacciatore. The lack of cross-examination was kind of thrown off our schedule for things. We have some Bluetooth speakers coming in to amplify the sound. The next item of business for the state was going to be published a 911 call. The court, well, it looks like your speakers just arrived. Mr. Cacciatore, oh, okay, great. The court, you spoke it into existence. If you want to deal with that issue, then if you still want to intend on calling CSI Abraham Moreno, I believe who was it next? Mr. Cacciatore. There it is. It's not CSI. It's just a regular witness. Yeah. The court. Oh, sorry. Okay. Is it Abraham Moreno? It's Abraham. Oh, Moreno. It's Abraham Moreno. Okay. Thank you. Appreciate it. I might have just misheard you earlier. Thank you. Just let me know when you've got that set up. All right. The parties are approaching the court. If I understood the state, this was going to be the last witness here today. Is that correct? Mr. Cacciatore. Yes, the court. Okay, all right. I have jury certificates for members of the jury to give their employers about the extent of service. I'll be given the same instruction I gave them before the lunch hour. Anything else we need to discuss before I give the instructions to the jury state? Mr. Cacciatore. Not from the state. Mr. Owens. It's a long weekend, you know. I guess a standard instruction would do it. Mr. Judge. It's going to be the same one that I read right before lunch. In addition, don't do any homework. Don't read the local news or newspapers. Okay. All right. Thank you all very much. What's the 3-day weekend in October? Is it Indigenous Peoples Day? I don't remember there being a 3-day weekend. Maybe it is Indigenous People Day. I should know my holidays, but I don't. All right. We're at the bench again. The court says, yes, sir. Mr. Owens. Judge, I understand there was a delay. The security said that on Mondays, it's a really long line trying to get into the courthouse. The court, correct? Mr. Owens. So they have to go through security. Is there any other way? And I'm just suggesting, is there any other way they can get some kind of a secret pass to get through the side door like we do? Ooh, a secret pass? The judge says, I don't believe so. Mr. J. At the front entrance of the courthouse, the far right is the juror entrance, and I just think you should remind them that they can use that far right entrance and not get into the long line. The court, sure, I can do that. Mr. Owens, that's probably what happened. The court, yeah, that'll be my guess. Okay, anything else we need to talk about? No, sir. All right, very, very good. All right, what do we got here? Is this a long one? Not too long. Okay, I'm going to read some of the questionings of the back and forth testimony. Sorry, I'm going to read the testimony, the back and forth questions, just so we can get context of where we are at and why there is an objection. So this is testimony right now. And who is testifying? Who is testifying? Something about autopsies? Maybe this is this might be the medical examiner, maybe. All right, question. Who's asking the question? Maybe Mr. Owens? I think it's Mr. Owens. Oh, God, I think it's Mr. Owens. Okay. If it's not Mr. Owens, I'll let you guys know. Question. Okay, so really from that time, I guess it was 11:30 that evening, were the videos then you understood that the body was found to be around 12 o'clock later, 12 hours later the next day or so? Would you agree that the death occurred sometime within those two periods of time? Answer. Yeah, I would agree. Question. But we don't know exactly when that is? Answer. Yes. Question. So it would be a guess if we would try to speculate about that. Answer, yes. Question. Now, considering the 3,000 autopsy, how many cases have you ruled the cause of death as positional or postural asphyxia? Answer, handful of times, not very common. Question. So about 5 times or less? Answer, yes. Question. And we're going to talk about the environmental suffocation a little bit, but let's talk about positional asphyxia component. What was your ruling? Those 5 cases that you ruled that it was positional asphyxia. What was your ruling in terms of your diagnosis? Mr. Cacciatore, Your Honor, I'm going to object as to relevance. The court says approach. Now we're at the bench. The court. What's the relevant in these prior findings? Mr. Owens. I think, number one, she's going to say that it's an accident. I think it's the literature that says the majority of these types of positional asphyxias are accident cases. The court. So how is that relevant? Mr. Owens. Well, it just shows that this type of scenario with this type of asphyxia, positional asphyxia, that the majority of the cases are accidents. The court. Okay, you repeated the same thing again. How is that relevant? Mr. Owens, that's all I've got. The court says, okay, I'm going to sustain the objection. Oh, Mr. Owens. Oh, how I missed you, Mr. Owens. He's a funny guy. Mr. Owens. The judge is like, okay, so how is that relevant? It just repeats the same thing again, but like in a circular manner. Not a holiday in Florida. It seems like it was a court holiday. The court had off. Oh, Mr. Owens, you're so funny. All right, next one. We got Orange here at the bench right now. The court. Where are we in the state's case? Presentation perspective. Mr. Cacciatore. We have 2 witnesses on deck. I would imagine Miss McCaskill would be a shorter of the 2 witnesses. We also have Miss Udon, whose testimony I think is going to be a little bit longer. I'll leave it to Mr. J. He's handling those witnesses as to affixing a time frame. The court. Well, the reason I'm asking is it's 11 o'clock. I don't know if we want to take our mid-morning break at this time or... And then with that late start, we didn't start until approximately 9:45. I'm on board with working a little bit later this morning. Mr. J, we can ask them if they need a break. Otherwise, we're ready to do 2 more witnesses for the lunch break. The court. Perfect. Okay, very good. I don't know why I decided to read this. Why did I highlight this? I don't know. Just for fun, I guess. I don't think Mr. Owens is used to a judge required him to cite case law, lawful reason for objections. I mean, isn't that how they do it in court, though? What is Mr. Owens doing? Oh, Mr. Owens, he's a funny guy. All right, we are at the bench right now. Court says, yes, sir. Mr. J. Judge, at the end of the session in the morning, we've already had some outbursts from the media. I don't know if you want to address that, but this afternoon, there's a lady in the back row on your left in the very far corner. She's already making outbursts. She's already going to cause a mistrial if she's to remain here. She's been going back and forth with the deputy. Mr. Owens, I thought she knew the deputy. The court, who might it be? Mr. Owens, the black female on the far right or far back. Mr. J, the female deputy can come up and tell you what's going on, I think. The court, my CO, Officer Jones. Okay, are we having an issue with somebody in the gallery? Oh, I remember this. There was someone in the gallery that was excused, and then she said something really weird as she was leaving. Like, bless you guys, and something else or something like that. I don't know. I don't know if they were like, I don't think they were in support or against Sarah Boone, but I think they just wanted to just be there because this was like a highly publicized case or something. I don't think we heard from them ever again. All right, so at this point, the court deputy comes up, says, well, what happened was when she first came in, I initially assumed that she had a court herself, which I told her just go to 19 Alpha. And then when I came back in, she was like, Officer Jones, you're fired. Damn, we got a Trump over here. And Deputy Bruce talked to her, so I assumed she wanted to watch Sarah Boone. They was inmates together, but she, the court. All right, so here's what I'm going to do. Thank you. The deputy court. The court. Mr. J, any further inquiry of Officer Jones? Mr. J, don't you all have anybody else? Mr. Owens, just the older man with, gets cut off. The court, I recall him being on the phone. Mr. Owens, he's older and he's hard of hearing. I've talked to him outside, so I think it was inadvertent that he needs to be. Gets cut off. The court, okay. Do you have any other inquiry of Officer Jones? Mr. J, no, sir. Counselor, Mr. Owens, nope. Okay, thank you. I will advise them to please silence all their cell phones so they're not going to have any outbursts. And if you cannot control yourself, I'm going to ask you to remove yourself. And if I hear an outburst, you will be removed. Okay? Mr. J, thank you. The court, okay, thank you very much. Anything else? Yes, sir. Mr. Owens, we have a lay witness. Her name is Pearl Walker. Oh, I remember Pearl Walker. Poor sweet old lady. She's an elderly woman. She lives here in Orlando area. She's cared for by her daughter, Marlene Walker. She said this, I understand my mother would be a good witness for Sarah. I just have to care for my mom. And we've had a significant loss in our family over the last year. My father, who she was married to over 60 years, passed away in May 2023. My oldest sister and her daughter passed away within days of each other. Oh, so sad. We have a funeral for them in the February 2024. She wakes up most morning crying due to the loss of her loved ones. She's 81. Damn, and they got her to testify? I mean, I guess so. Her heart could only take so much. I just took her on Saturday to get shots in her knees to help her with the pain of walking. Mentally and physically would be a lot to have her mother come into the courtroom. Is it possible she can participate via Zoom? Oh gosh, poor Miss Pearl Walker. Sorry, when I read these, I don't breathe properly, so my nose is like a little stuffy. How is everyone, by the way? How's your guys' weekend? Hi, Romania. How are you doing today? All right, so we're talking about Miss Pearl Walker. Poor Miss Pearl. Mr. J, You're looking at me, so I'm going to give a response, Judge. I believe testimony by video is something that should be addressed with a motion, so the state can respond and the court can issue a ruling. Quite frankly, two of the, I don't know, as far as I know from the communications with the defense team, they narrowed down to 3 civilians out of the plethora that we've had that they're going to call. This is one of those 3. One of them I can kind of understand what the testimony is based on the phone extraction. That's Deborah Johnson. The other 2, we have actually no idea what they're going to say. And I understand that they have an investigator who has been in trial with us every day, rather than perhaps getting us affidavits to give us any help. So we're going to require, unless the court orders otherwise, an in-person deposition. The court. Are these one of the persons that were identified in your objections? Mr. J. Yes. Who was it? Because I only have initials, unfortunately. Mr. Owens. Pearl Walker. PW. Okay, got it. Based on the court's ruling early in the case, if you were going to call any of these people, they need to be subject for depositions first. Mr. Owens, I think we got some scheduled for as soon as we get out of here, 5:30. We've got witnesses coming to be deposed, but I think Billy Lane had actually interviewed her and he's got a summary for her testimony. I'll get it to the state so they know. But I do have Marlene Walker and Pearl Walker some phone numbers so they can call. I just talked to them during the break. That's the reasons I'm giving this information. The court, sure, Mr. J. I'm not going to talk to witnesses on the phone and have unrecorded statements that I can't testify to. I need their depositions. The court, that was the court's ruling. Mr. Owens, I understand. Mr. J. But if I had an insight, then I could perhaps discuss the reasonableness of video testimony, but I don't have any insight of what these people are going to say. Mr. Owens, can I try to get them here at 5:30? Mr. J. Well, we've got to decide how late we're going to stay in the courtroom. The court, yeah, okay, so bring up the other issues. Are there any other issues? Mr. Owens, yes. The assistant to Mr. Brandon, he lives down in West Palm. Right. Mr. Owens, good afternoon. This is 1:36 p.m. reaching out to see when you anticipate meeting Dr. Brandon. We kept his schedule open for Wednesday, October 23rd, but I need to know if he'll be needed that day as soon as possible. Please. So that's something we need from the state to know whether or not he can testify on Wednesday. And then on the other thing is that I got something from Dr. Harper. She's in the Bay County homicide or sentencing on a death row case. The prosecution is still on today. They asked me to be in the Bay County tomorrow, which would be Wednesday, and will send me on an update at 5 o'clock tonight as to what time I need to go tomorrow. If that's late, last witness, I would expect cross to be Wednesday a.m. I will text you as soon as I hear anything at 5 o'clock. So I know something from her at 5 o'clock today, Central, 5 o'clock Central Time. It's kind of hard reading his words sometimes. I feel like it's kind of like all over the place. Okay, so it was Australia, right? Australian lady poisoned 4 in-laws claimed to have bowel cancer. 4 in-laws? What? What was the motive? My goodness. Okay, so Central Time, 5 o'clock. The court, okay, tomorrow's Tuesday. Mr. Owens, what's today? Monday. The court, today is Monday. So she's set up to testify on Wednesday in Bay County. Mr. Owens, that's what she says here. The court, okay. Mr. Owens, she says they asked me to be in the Bay County tomorrow and will send me an update at 5 o'clock tonight as to what time. Hi, Carolyn. How are you doing today? Hello. Mr. Owens is a funny guy. I feel like Mr. Owens is a lot of like talking and not a lot of listening sometimes. So tomorrow is going to be Tuesday. Huh? Then what's today? It's okay. It happens. Sometimes your mind is just wandering, I guess. The court. Excuse me. I would very much appreciate it if you all could just keep your comments down. Thank you. Mr. Owens, here's the court. I have no reason to doubt that what you provided to me, okay? I don't know the order of proof you intend on putting on case. I don't want to pre-state anything, but it seems like, Mr. Owens, Sarah Boone is going to have to go first. The court, correct, Mr. Owens. And so that's going to probably be if you all finish. Oh, that's Mr. Owens, I guess. So that's probably going to be if you all finish, gets cut off. The court, I would assume that it's going to be the majority of Tuesday. Listen, can we get the jury in here on how late they can go? Mr. Owens, okay. The court, assuming we can go to 5:30, I don't know, 6 o'clock tonight. Damn, I forgot. I think it was the Sarah Boone trial that we're going on so late. Man, unlike the Karen Reed trial, we get it out early. All right, the court. Assuming we get to 5:30, 6 o'clock tonight, that still leaves your cross-examination of Detective Capsule tomorrow morning, which you said would be around, I don't know, 30 to 45 minutes. Assuming worst case scenario, you start promptly at 9 o'clock, you're at 9:45, approximately 15 minutes for rebuttal, for redirect, just being worst case scenario. 10 o'clock, state rest. We have JOA and colloquy your client on a couple of things we've got to go over, which means we kick off your case at 10:30. I don't know how long your inquiry will be. I don't know if it's like 2 hours long or longer than that. Assuming 2 hours, that takes us to 12:30. We take an hour and a half break and come back at 2 o'clock. 2 hours for cross-examination. Basically, Tuesday is Ms. Boone's testimony, which then leads us to Wednesday. Now, if Dr. Harper's testifying in Bay County on Wednesday, I don't know how your order of proof on who you want to present when, where, how. Mr. Owens. We'll probably try to have Brandon's available Wednesday, so we probably would want Brandon. Mr. Beck. Mr. Beck. Oh, Mr. Beck. Okay. Just got off the phone with Dr. Brandon's office. He's scheduled to come in Wednesday, although I'll have to let him know because he's scheduled a doctor's appointment anyway. But I think he's available Wednesday morning, first thing, early in the morning. He's 3 hours away, so probably, maybe 10 o'clock is a good estimation for his arrival and testimony. Julie Harper told us originally that she would be over testifying on Tuesday. We got an email from her over the weekend saying her testimony was going to be Tuesday or Wednesday morning. That's okay. I think that the court... I think the text updates that Mr. Owen has provided looks like she's going to be testifying Wednesday. Mr. Beck. Oh, okay. The court in Bay County. I think we might have to be malleable with this. I don't want to press too hard this afternoon. I want to try to get as much as we can done. I'd like to have a clean break. I don't want to be in the middle of examination and have to pick up where we left off. Mr. Owens, judge, of course. We'd love to be finished by Thursday or Friday and have the jury with the case. The court. Okay. Mr. Owens, that'll be your goal. The court. Fabulous. All right. We may have to just revisit scheduling stuff either at the close of business today or tomorrow to figure out where we are. So in regards to Ms. Walker, PW, look, I already ordered that she's going to give a deposition before she testifies. Now, if there is investigative summaries or something that Mr. Lane can give to the state, they can make a decision on what they want to do. They can waive the right for a depo. That's a decision. With regard to the virtual appearance, I need you to file a motion. Explain to me that you told me and anything else, and if the state has provided a summary that may assist in a response in that matter. And then the last thing to address is just discussing with our members of the gallery as to the silencing of cell phones and controlling themselves in that regard. Mr. Owens. And then you can ask what the jury, what did you say? And then you can ask the jury, okay. Mr. Owens. And then you can ask the jury about how late they want to go today. The court, I am, Mr. Owens. And based on that, we'll try to coordinate depositions. The court, correct. So the only issue is that we may have to send them right back because of the one juror I can't recall where she's situated. She has a minor child care issue where she can't go past 6 o'clock. So we got to vet that out. Now, if she cannot get coverage or if it's me and me only, I'll bring you back here. We'll figure out where we want to break because I don't want to derail anyone's presentation in any way. Okay? All right. Anything else? No, sir. No, sir. All right. No issues here. Whew. Good podcast. Mushroom Case Daily. Are they covering the trial right now? How long do they expect the trial to be? All right. We are at the court right now. The court says, yes, sir, Mr. J. According to my victim advocate, the defendant keeps on turning around and smiling at a woman in the last row. That's going to be a potential problem. I'm really, really concerned that she's going to see something to derail the trial. Mr. Owens, I'll tell my client not to turn around and talk to people in the audience. The court, I just saw her. Mr. Owens, or make comments to people. Unless you want to do it, Judge, I'll let you do it. The court, I just saw her turn around and make eye contact with someone in the gallery, and it was not your staff. Mr. Owens, I'll tell her, or you want to tell her. The court, I prefer you to tell her, and I would inquire of her specifically as to if she knows anybody and how she knows those persons. And I need you to come back and report to me what it is. So I remember when we were watching the trial, people were speculating that Sarah Boone had a girlfriend that was in the courtroom, maybe. And they were speculating that this girlfriend had also served time with her at the Orange County jailhouse. But I don't know if any of those rumors were ever substantiated or anything, but I remember hearing that floating around. 5 weeks trial? Mr. Henderson. Is it the same person before? The court. The same woman before? I don't understand. Mr. Henderson, who made the comments to? Mr. J. Yeah. Mr. Owens. Sarah Boone says she doesn't know anybody in the gallery, but because of all that we just said, she was just looking to see who it was. The court. All right, Mr. J. Mr. J. I know it's a public trial, but that woman is going to cause a mistrial. Mr. Cacciatore. At this point, I think she's forfeited her right to be here. The court. What exactly have you seen her do specifically? Mr. J. Well, before you came in here, she yelled something out. What did she say to? Mr. Cacciatore. I believe it was a loud conversation going back and forth, and just given the sensitive nature of this, we picked 8 alternates for a reason. We won't be able to unring any of these bells. She doesn't have any business here other than the fact that she's a member of the public and she's forfeited her right to continue to stay in here. Mr. Owens. It is being live streamed. I know that. Mr. Owens. So people can watch it. Mr. Cacciatore. I think defense is in agreement that she should leave. Mr. Henderson, I'm in 100% agreement because of this. If something happens now, we've been into this thing. The court, I know. Okay. Mr. Henderson, all the safeguards, Judge. The court, politely, any thoughts from either the state or defense as to how to ask the woman in the back left to excuse herself? Oh my God, this judge is so nice and polite, man. Mr. Owens, just the fact that when security officers walked in, she said something in a loud voice. Oh, here comes the deputy, whatever her last name is. Here comes, even though it was off the record and you weren't on the bench, it's still inappropriate in a courtroom. Some people don't know how to act in a courtroom. It's just inappropriate. Then she called out, hey, does anybody got a pair of eyeglasses I can wear? I turned around and said, what number do you need? Is this Mr. Owens? Somebody in the front gave her a pair and she tried them on and gave them back, but just to relax. She's to relax the seriousness of these proceedings. Mr. J. I think perhaps even before Mr. Owens got in here, when she first came in, the female deputy, the Orange County employee, told her to go up to 19A. I know who you are from the past. I don't know if she's another defendant or because I couldn't hear what she said when she was up here. I was behind her. The court. She said that she was supposed to be that woman was here for court and directed her to 19 Alpha, and that was when the squabbling had begun. So, Mr. Henderson, what about the request of counsel? You can even put my name in it. I don't care. Damn, Mr. Henderson. The court, all right, Mr. J. She had another outburst when she said she was a mayor of Orlando or in charge of Orlando, the entire city or something like that. The court, I got it. All right. So here's what we're going to do. I'm going to say at the request of both the state and the defense, ma'am, in the back left last row, I need you to excuse yourself. You're able to watch it live. The court's link is streaming. You can go to 12th floor and call my JA and she'll give you instructions on how to watch it from a streaming device. Is that acceptable? Oh my God, the judge is so nice. He's like, I don't want to kick this woman out even though she's being disruptive. How can we say it in such a nice way? Mr. J. Thank you. The court. Okay. Thank you very much. So at this point, this is where the judge tells the woman to leave. All right, ma'am in the back left last row. Ma'am in the back left last row. Good afternoon. After conversing with the state and the defense, they have agreed and asked me to excuse you from this room. I understand there may have been an outburst by you with courtroom personnel before the judge arrived on the bench this afternoon. If you would like to watch the trial, it is being streamed live. You can head to the 12th floor, get off the elevator, head to the south side of the building, and you will see signs where it says Judge Michael Kranick, and it will tell you which direction to go. You can pick up the phone, call my judicial assistant, Anita Barrios, and she can give you instructions on how to watch this trial virtually. Okay? Unidentified speaker. Okay. Thank you so much. Thank you, ma'am. God bless you guys. I'm still the boss of this city. We still got work together and try to figure it out together. All right. Thank you, ma'am. So they got her arrested. Have a good one. All right. Thank you. Bye. Yeah, I remember they left and that was just about it. You know, no crazy outbursts, you know, nothing too crazy, nothing like violent or anything like that. They just said something weird and then they just got the fuck out. So all right, bench time. Where are we at in the trial, do we think? Have no idea. No clue. I wish they would set the days on the bottom of the transcript or something, just so we have like a little bit of idea of like who's testifying, what day it is, where are we at. But we're at the bench right now. The court. My takeaway, Mr. Owens, is that you do not have the opportunity to review it yet, so I was tabling it for a moment. Mr. Beck. Well, it should be done in camera is what I'm saying, not in public. Mr. Owens. This is not in camera right here. Mr. Beck. It wasn't. The court. we're at sidebar. I don't know if that's in camera, nonetheless, if you're in the position to address it now, I'm fine with that. My takeaway is you are not. Mr. Beck, I briefly looked at it. They haven't even looked at it. I was just trying to understand where he was coming from. Is he saying that we're going to request costs for post-conviction travel costs? Mr. J, do you want me to say what I want to say? Yes, Mr. J, please. Mr. Owens, yes. Mr. J, okay. Here's my concern. The defense team is comprised of 4 attorneys, a trial jury consultant, and I don't know what their backup support staff is. But beyond that, the only thing that I notice is getting paid for the JAC is Billy Lane. And the experts, Mr. J, and the experts. But beyond that, this is a tremendous expense to come down here, shut down. I believe he described it as shutting down his practice for a month and coming down here. And speaking to one of the other members of the team, it seems like other members of the team are getting paid by Mr. Owens. At the end of the day, I'm wondering, where is this money coming from? I think we're all wondering that as well, and they addressed that. Is this just a charitable gift? Which is fine if Mr. Owens wants to provide a charitable service and get his pro bono hours for doing this case for Ms. Boone. That's fine. But if that's some sort of deal with Ms. Boone about story rights, anything like that, then there becomes a potential conflict of interest. I don't want her to make allegations in a 3.850. If she gets convicted, we all know there will be appeal. If there will be a 3.850 if the appeal fails, and I don't want anything to be about a conflict of interest saying, well, I would have pled, but my attorney didn't do what he should have done in getting me pled, for example, because of the contractual agreement we made for how he's going to get paid for all of this. So the state doesn't even need to be a part of it. We just want to prefer that there's an in-camera hearing so that this can all be put on the records. See if there's an actual conflict or if there's an actual conflict to whether Ms. Boone, under the case law, knowingly, intentionally waives any conflict for purposes of 3.850. After that in-camera proceeding, it can be sealed and unsealed if there's like 3.850 someday. Mr. Owens, I think we need to address it later. There is no deal. There is no conflict. The court, I'm going to give them the opportunity to review it. Mr. Owens, we're going to address it on the record, the court, and discuss it themselves. I'm not going to address it right now because by your own admissions, Mr. Owens, 2 or 3 of the members of your team have not reviewed it. And Mr. J, I do have a slight correction. My understanding is that Mr. Henderson's daughter was recently barred, so there are 4 attorneys working over there. Mr. J, that's what I said. The court, I thought you said 3. I apologize. Mr. Owens, she hasn't filed a notice of appearance. The court, I understand. As an attorney on record, the court, I get it. Let's table it. I'll look at it during lunch hour and we'll readdress it if necessary this afternoon. Congratulations to Mr. Henderson's daughter. Anything else we need to adjust, Mr. J? No, sir. Anything else we need to address from the housekeeping perspective, from your all side of the ledger? No, sir. All right. I mean, they did address the book deal thing. I don't know how that book deal thing came into rumor. I wonder if it was something that was started on the internet and then Mr. J picked up on it, or who started this rumor? But it was addressed at court on camera, and Mr. Owens said he was not getting story rights or anything like that. But I do remember Mr. Owens saying that he had to shut down his law firm for like a month in order to do this. So if I was Mr. J, I'd be a little bit sus too. Like, where is this money coming from? From the jail messages, you think? I don't know if I heard anything about that. What did you hear about the jail messages? All right. Again, we are in testimony right now before we go into sidebar. Is this the detectives, I think? I think this is Chelsea Kepsel, maybe. Jail messages, Sarah talking to, video producers? Interesting. All right, question. At that point in time, have you told Ms. Boone she was under arrested? Oh, I think this is maybe Mr. Owens, maybe? Is this Mr. Owens? Mr. Henderson or Mr. Cacciatore? Mr. Henderson. I think it was maybe Mr. Henderson. Okay. At this point in time, have you told Ms. Boone that she was being under arrest? Answer. I told her at the end of her interview. Question. Before the interview? Answer. No, I did not tell her before the interview. Question. Ma'am, why didn't you tell her before the interview? Because he wanted to get some answers out of her. Mr. Cacciatore, Your Honor, I'm going to object as to ask and answer. The court overruled the witness. So I have to read her Miranda warnings, and that's what I did. I don't have to tell her she's under arrest at that time. Mr. Henderson, was there a reason? Could you have told her that she was under arrest before reading her Miranda warnings? Mr. Cacciatore, Your Honor, I'm going to object as it calls for speculation. Sustained. Mr. Henderson, Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings? Mr. Cacciatore, Your Honor, I'm going to object to relevance. Approach at the bench. The court. How is the sufficiency of Miranda a fact of consequences for the jury to consider? Mr. Henderson. It goes to the voluntariness of her statement, Judge. The court. But isn't it that an issue for the law for the court that was previously decided in the motion to suppress? Mr. Henderson. The issue of the law for the court if the statement comes in, but to the weight they give the circumstances around the statement and everything else that takes place around the statement is totally relevant. Anything further, says the court. Mr. Cacciatore. Your Honor, the jury instructions don't contemplate the jurors relitigating the motion to suppress. They are given specific instructions about that deals with them weighing the voluntariness of the defendant's statements. But that analysis is predicated upon the objective four corners of the evidence of the defendant's statement, the conduct of the officers on the video towards her, the fact that the defendant would be aware at the time, but in that analysis, the officer's subjective intent is really irrelevant. What's relevant is their objective conduct towards the defendant and the facts that she would have been aware of. Yeah, Sarah Boone got really pissed because she came in hoping to get her phone back and she was yapping away. And then at the end, she was caught off guard, I guess, that she was being arrested. And she felt like she was being tricked in order to be there. And they manipulated her. Dude, the look on her face when they're like, yeah, we're arresting you. And she's like, what? Because remember, she had like a list of questions that she wanted to ask. She's like, okay, well, I have a list of questions. You know, do I get the ring back? When do I get the ring back? Okay, and when do I do this? When do I get this? Okay, how do I do this? How do I do that? And then it was like all pointless anyways because they were just going to arrest her. All right, the court. Anything further? Mr. Henderson. Yes, Judge. I believe there is a difference with people when they knew that they are under arrest, because then when the Miranda warnings are read to them, they have a different idea before they are read it. And I believe law enforcement knows that, as I believe this was a strategic decision for her because she was more likely going to talk to us about knowing that she is not under arrest. The court. I'm going to sustain the objection because I don't think subjective analysis from law enforcement and the question seems to be geared towards the officer's subjective analysis. It's whether or not the jury instruction 3.9b as to whether there was a force or whether anyone made promise or whether it was freely or involuntary made. It seems to be from the perspective of the defendant, not from the perspective of the law enforcement. So I'm going to sustain the objection. Next one. All right, the court. Can the parties approach for a moment? I understand what it is that you want to do. I get it that you have not participated in the viewing. My most pressing concern is our time with our jury. We have wasted substantially amounts of it. Oh, this is with Mr. Owens. The viewing of what? Something about Dr. Brandon. Dr. Brandon. What are we talking about here? Oh, okay. I remember this was a long one, but I think this was done in open court, right? Yeah. Dr. Brandon was an expert for the defense. The overt act. Okay, remember overt act. All right, let me just read the rest of it and we'll circle back possibly. Okay, let's do this. Mr. Owens, Judge, I don't know if I would have to say wasted. I mean, we've been working. From the judge, from their perspective. That's right. Okay, so I think they were basically, they had the jury excused, and during that time they were doing something, and then Mr. Owens was like, well, actually, you know, I need to do something. I need to talk to her or something like that, and it's gonna take me 15 minutes. And then the judge is like, well, we've just been here and the jury's been waiting. Why didn't you do it during that time? And we're wasting time here. And the judge is like, we're not wasting, or so Mr. Owens like, we're not wasting time. We've been working this entire time. All right, so the court. Okay, they're sitting in that room waiting to be brought in, and now I'm going to bring them in and excuse them again for early lunch. I understand that's a lot of work and everyone is doing an excellent job so far, but we need to be more efficient with the time that we have. If there are exhibits on either state or the defense that intends on using, let's pre-mark them during the break, all of them. So we maybe not get the rebuttal evidence because the defense had not arrested yet, but at least for any evidence you intend on eliciting over the next couple of days, let's go ahead, pre-mark it so there's no concern, no question, no last minute markings. If it comes up, we will address it. Mr. Owens, can we do it during lunch? The court, we're going to recess in the next couple of minutes. Mr. Owens, can you give us and the clerk some time? The court, I will have Madam Clerk stay behind so that you guys can do that. Oh, poor Madam Clerk, no lunch for her. The state should probably be here for it to confirm. We'll bring the jury in and I'll ask them to be back here at 1 o'clock. And at 1 o'clock, we need to be ready to go. Mr. Owens, I understand. And Judge, if I started, I wouldn't be finished before lunch. I understand that. Mr. Owens, it'll be broken up anyways. The court, I agree with you. I'm trying to avoid it. Mr. J, Judge, I've had an opportunity to take depositions of the last 2 witnesses last night. I'm just curious as to when this 3rd witness is flying in from Jersey and is going to be deposed so we can start making arrangements with that court reporter. The court, who is that? Mr. J, I believe it's Deborah Johnston. Who's Deborah Johnston again? Mr. Owens, I think there are people that 4.5 years ago were tenants of the apartment when this occurred, but they have been dispersed. The court, so you took PW and who else last night? Mr. J, I would have to see her full name. Last name is G. All right. MG? MG. All right. Got it. All right. And then as for, okay, when do we expect Miss Johnson to be arriving from New Jersey? Mr. Henderson, we tried to contact her last night, Your Honor, and she was asleep. The court, okay. Mr. Henderson, we're trying to work with Mr. Owens, United Airlines, flying in, I believe, Wednesday at 9:05 a.m. Mr. J, guess we're doing it Wednesday night. Mr. Owens, it'll be Wednesday morning. Mr. J, right. The court, correct. I see arrival time at 9:05 a.m., so it's either the lunch hour or Wednesday evening, because I don't know with when the defense intends on offering that testimony. But in my pretrial ruling remains the same, that before the persons are allowed to testify, the state has the opportunity, and similar with you, if it's a rebuttal witness, you'll have that opportunity as well. Okay? Did you have an opportunity to address the USB to the CD conversion? Because it was on my list from yesterday. Oh, I don't think this is important. USB to CD conversion. That sounds fun. What do we got here? Question. Is this when? Oh, this is when Sarah Boone is testifying on the stand. Okay, so we're at this point. Sarah Boone is testifying on the stand and direct examination by Mr. Owens. Mr. Owens. Oh, now we know why it was like the questioning happened the way it did. Because remember how when Sarah Boone was testifying and they were like, Mr. Owens seems like he's really kind of like guiding her and leading her a lot. It's as if he's testifying for her. All right, question. Okay, now I want to get directly to the date of this event so that the jury can hear your testimony. All right, so tell us. I believe the date is February 23rd of 2020. Explain to the jury that whole day from the time you got up, the whole thing. Mr. J, objection, calls for narrative. The court, approach. The court, response. Mr. J, I'm just making sure. Is there a reason for the narrative? Mr. Owens, I mean, I could break it up. I could break it up. The court, then go ahead and break it up if there's not any. Mr. Owens, if there's anything wrong with me saying, can you tell me what happened that day? Let her tell it. I mean, he was wanting a narrative to begin with. I'm giving her the opportunity. Mr. J, here's the issue. I was just making sure that we weren't getting to the stage of ethical issue of having to give the narrative. But if we're not, then I'm just hopeful that, like a prosecutor would have to do, that he would come up with a few creative ways of saying what happened next so I can, so it's not a narrative and we can break it up and object. Mr. Owens, you see me guide her. She tried to go off a couple of times and I tried to get her back. The court, I'm not going to allow a full-blown narrative. If you want to start morning, afternoon, break it up into chunks of time, I'll allow that. All right, I appreciate it. All right, still in the Sarah Boone testimony. Who is this? I think this is still Mr. Owens. All those things said by the men were said by George in the last 2-minute video. Answer, correct. Question, all the words said by the female were said by you in that 2-minute video. Answer, correct. Question, were you intending on showing him the video the next day? Answer, yes. Question, at the time or the next day, is it fair to say you don't remember videotaping? Answer, I do not. Question, okay. So for what you can tell me from watching it, did that refresh your memory about that event? Answer, it did. Question, what did you say all that? Why did you say all that? Objection, may we approach at the bench? Yes, sir. Judge, it's my position that they have not established an overt act. I understand it's one of the things to allow her to testify about why she did these things. Oh, that's right. We were arguing about the overt act. What did George do that prompted Sarah to do what she did, right? The overt act. Oh, we were juggling our memories. I understand it's one of those things to allow her to testify, but why she did any of the I understand it's one of the things to allow her to testify, but why she did these things. But I don't want that to be considered a waiver of any objection about reputation, past violence, and battered spouse syndrome coming in a different way. The court response, Mr. Owens. Well, Judge, this event is broken down to 2 minutes. Why did she say what she did when was recorded? Why did she say what she did and was recorded? And I think she's going to say, I was angry at him. He was in a confined space. He was not free to get out, and it was my chance to tell him how I felt. And then, of course, 11 minutes later is the 22-minute video. The court, 22 second video? Mr. Owens. Right. 11 minutes later, the 22-second video, there's an 11-minute period where she's got to testify about what happened during that time. So, I didn't know she was going to say she was incarcerated. The court, I know. I don't think anybody anticipated that. Mr. Owens. So some things come out of clients' mouths that we don't expect. Mr. Court, I understand. Mr. Owens. If you want to proffer it outside the presence of the jury, but I think I'm going to say, why did you say those things on that 2-minute video? And I think she's going to say, because I was angry. I wanted to tell him how I felt. But that's what I believe the answer is going to be. Not because, well, you choked me and you know what you done. The court, is it possible the question to avoid any prior instances coming out at this point in this time? Is it possible to rephrase the question specifically as to the feelings that she had been having at that point in time and only those things? Mr. Owens, okay. The court, so that we avoid that issue? Okay. All right. So they're basically trying to avoid any prior instances coming out between Sarah Boone and George. That's why the judge is asking Mr. Owens to just isolate about her feelings about that time. Not why she'd do it, and maybe she did it because, George did X, Y, and Z to me before. All right. Question by Mr. Owens. Again, this is still, I think, Sarah Boone. Yep, Sarah Boone's on here. How did George's drinking adversely affect you? It would debilitate my ability to help him the way that I was always trying to help him. Because it would be one good day, a day of survival, and then it would be another day when I'm having to peel him off being called 911. Question. Why would he get that way? Tell us his pattern as it relates to drinking. And then, Mr. J. Judge, object, approach. Mr. J. Judge, I don't think pattern is appropriate. If there are specific instances of violence that the court, are we getting into reputation? What are we getting into? Mr. Owens. I think it's consistent with what I've argued before, that when there are times when, he would drink and then she'd just come over, you just get to know a person, you're living with them, you're an intimate partner. Over the time, you learn that when he gets to a certain level of intoxication, that he gets sad or moody, and then eventually he gets angry, belligerent. And then there's times where he gets violent with Sarah. So it's just a cycle. That's why she said I was trying to keep him occupied the next day, because she knew that if he's got the alcohol there to drink, he's going to consume it. And then it might be at a point where they get into a violent episode, and that was just that they were going 3.5 years, so you can imagine there's a lot of history of that going on, and I'll refer to it as the court. Any other further argument? Mr. J. I just think we should get into the specific dates, get into those, because one person is not a broad enough community for reputation evidence under the rules. Mr. Owens. And she's not going to say remember every date, Oh, she's not going to remember every date. Yeah, it'll be hard to remember. Hi, Lauren. How are you doing today? Hello. How's it going? Mr. Owens, and she's not going to remember every date, Mr. J, let's go through what she remembers. Mr. Owens, excuse me. Mr. J, let's go through what she remembers. Mr. Owens, part of the syndrome, the court, Mr. Owens, part of the syndrome of battered spouse is depression and then not having a good memory about all the events due to the repression to, or whatever the doctor testified to. Is not having good memory about the event due to the repression or whatever the doctor's going to testify to. But there's going to be evidence that the court, my concern is utilization of the word pattern. It sounds like we're getting to habit evidence here, which is, I don't think something you can get into. Now, you want to rephrase it and say, this is what would happen and this is the circumstances that seem to continue. It might be a different story. But the word pattern is something I've got a problem with. Mr. Owens, tell me what you all are thinking about, because I don't want to violate the court's ruling. The court, my understanding based on the case law is that there can be reputation evidence for prior incidences, and we're kind of dancing between the two of those. And this is what generally what would have, sorry, and this and that this is generally what would happen. He would drink, become emotional, become sad, and then aggressive. The state's concern, I think, is that the use of pattern, which I think we're going to habit and routine practice, which I don't think is permitted for the circumstances you're trying to offer it for. Mr. Owens, okay. The court, so you can rephrase it, and then we need to start getting to specific instances. Mr. Owens, okay, thank you. Skip this bench. Next bench. All right, who's testifying at this moment? They're at the bench right now. The court says, just a request from the jurors as relayed to me by the deputy. If the pictures are going to be shown, oh, I remember this. If the pictures are going to be shown, if they could be tilted so they're not landscape and vertical because they're tilting their head in a weird way to see them. Mr. Owens, my bad. The court, no worries, just for the future. Just wanted to let you all know. Okay, thank you. So basically, Mr. Owens, when you're giving pictures to the jury to view, have it all in one orientation. That way they're not breaking their necks to see the damn evidence. Oh, Mr. Owens says, okay, it's okay. It happens. All right, Sarah's still testifying. Owen says, Sarah, tell the jury, Mr. J, Judge, can we approach? Yes, at the bench. Mr. J, local administrative order, surnames. Mr. J, you're such a teacher's pet. The court, he's right, so please. Again, they don't want anyone saying like Sarah or like George, either say Ms. Boone or say Sarah Boone, not just like their first name. You may proceed. Question, Ms. Boone, tell the jury why you lied to the police. I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of calling 911 by telling them what happened. I thought they were going to help me, but instead I was arrested for calling 911. Question. So did you make the decision to lie? Question. Answer. I did. Question. Did you say with that lie? Answer. I did. Question. Are you telling the truth today? Answer. I am. It's like, yeah, I've been lying the entire time, but guys, trust me. I was lying before, but I'm telling the truth now, okay? Just like the Murdoch thing. I was lying before, I didn't trust law enforcement, but I'm telling the truth now. Sure. Her voice is more snarky. She wasn't snarky though when she was doing direct examination. She was like meek and like, I don't know, like a little girl's voice like this. Like I can't even do it, okay? It was like so like, she was trying to play innocent, okay? It was a little too much. Snarkiness is when do we, I think did she get snarky in cross-examination? I don't think she did, right? Sarah Boone's the type of person who doesn't really get snarky until it's in writing. Because I swear to God, when we see her writing versus how she would present herself in the hearings, in the case, that snark level was like not really there. It was like she really cares about her image, and the image is that, oh, look at me, I'm just a little victim, oh gosh. All right, let's read this one. Redirect examination by Mr. Owens. Yeah, cross-examination. I don't remember if she was snarky or not. Okay, Mr. Owens, redirect. Ms. Boone, he just asked you a question that you poked him and you didn't poke and you poke, and every time you poked him hard with the bat, he was inside the briefcase? Answer. The suitcase, yes. Question. The suitcase. But you remember when he put his hands out, did you not hit him in the hand outside the suitcase? Answer. Yes. Question. Okay. So that was the only time the bat touched Mr. Torres' body outside the suitcase? Answer. Yes. Question. Was when you hit him on the hand, but all the other injuries, were you poking him pretty hard? Oh gosh, I remember this. It was like, yes, George looked like he was beaten, but it wasn't because she was hitting him or swinging in the bat, like she was trying to hit a home run. She was just poking him. What do you mean? I don't know why the injuries look that bad. Answer. Correct. Question. I mean, you bruised your hand, correct? Doing it? Answer. Correct. Mr. Owens, thank you. That's all I have. Really? That's all he had for redirect? Or is this like a redirect, like redirect times 3? That's all he has? I don't know if I remember this. All right, ma'am, you can return to the counsel's table. Judge, can we approach for a moment? Just for a moment. Let me get her situated at the table and then we can approach. Defendant steps down. All right, come on up, you all. At the bench. Mr. Owens, Mr. Henderson has got some bad news. Okay, what's the bad news? Mr. Owens, I said you've got some bad news. Mr. Henderson, the bad news? The court. Mr. Henderson, can you get a little bit closer? Mr. Henderson, oh yes. The court, yes sir. Mr. Henderson, Judge, I let the officers go. I told them, like I informed the court, that I was going to do based on the time schedule that we're in. I know we're over. The court, that's fine, Mr. Anderson. I didn't think that was the court. It's 5:40. Mr. Owens, we don't have any witnesses. Oh, we don't have any witnesses. The court, I understand. We'll pick up tomorrow morning. That's fine. No big deal. That's okay. I anticipate the cross to be a little bit longer. I think we may all have been, but it's no big deal. Gentlemen, anything else we need to discuss before we go into the recess for the evening? Mr. J. No, sir. The court. Okay, let's be ready to rock and roll at 9 a.m. Yes, sir. Mr. Beck. I was just curious whether or not we're going to address the motion to stay filed this morning in camera evening, or are we going to do that later? The court. I'm not going to address it yet. We can just address it later when we get closer to jury instructions. Mr. Beck. That's why I was curious. Mr. Owens, we've got an issue. By 5 o'clock today, you ordered us to have redacted down the medical records. We need more time, Judge. Can we have a little more time? The court. Here's my concern. Mr. Owens. Mr. Beck is working on it. The court. Here's my concern. Is Dr. Harper is supposed to testify on Thursday, and the state needs to, understand what it is that you all are looking for. Mr. J. That's not the issue. I'm familiar with the records she relied on, and they can, of course, rely on stuff that's inadmissible. The court. Yeah, of course. Mr. J. Well, my concern is what particular pages do they seek to introduce? The court. Yeah. Mr. J. So it's a completely separate issue. I just need to know what they're seeking to introduce to see if I object, to see if it's complete, see if it's incomplete, and so on and so forth, like we did with the records. Mr. Owens, can we get you to an answer in the morning? The court, when do you anticipate on moving them to evidence? Mr. Owens, I need to talk to, I believe there's a case law that I can recall the client because she was going to testify to something that happened. And I believe that he got mad at her and he rammed his fist through the glass window or something. He got cut. So he had to go to the hospital. The court, okay, hang on. Mr. Owens, the evidence was going to be in those medical records. The court, let me do this. This is going to take a couple minutes for us to figure out. Let's get the jury out of here so we're not wasting their time. And then we can go from there. What was this again? They were trying to get something in that George punched a window, was admitted for medical stuff. All right. The jury has been dismissed. Let's see what happens. I don't remember this. The court. All right, with regard to the medical records, the court previously today had required by 5 p.m. to address those. Unfortunately, they have not been addressed. It is imperative that the state knows what it is or calling down or redacting, and I understand that you may want to be seeking those into evidence maybe tomorrow. The state needs to be advised as to what is going to be you're seeking to utilize. So where are we in figuring that out? Mr. Owens, can I have a minute with the client? The court, yes, sir. Mr. Judge, or Mr. Owens. Judge, we've had discussions with Ms. Boone, and she claims that every time he went to the hospital, the medical records would show that it was in relation to some type of domestic violence involving her. We've expressed to her that we do not wish to pursue it and introduce those records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that? The defendant, yes. Yes. The court. Okay, ma'am, earlier we had discussed. Anything else you want to add to Mr. Owens? I think that's it, right? So she wants to introduce those medical records, and the defense team is like, nah, let's not go down that road. It seems. Dun, 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 dun. Question. Who is this? I don't know who's asking the question. Objection. Maybe Mr. Beck? Now you're familiar with the fact that there is a special jury instruction that's been recognized by the Florida Supreme Court. Mr. J. Objection. Approach. Hey, go lucky, how are you doing today? At the bench. The court. Legal grounds of the objection? Mr. J. He's not qualified to get into legal objections. And quite frankly, the law is the purview of the court. We don't know whether this special instruction is to be given yet. The court. What are we doing, Mr. Beck? Mr. Beck. Just having indicate that battered woman is identical to battered spouse as indicated in the jury instruction. It's just the same terminology. Same issue. The court. I'm hesitant to address jury instructions. Mr. Beck. Okay. The court. We haven't had a charging conference. We haven't agreed on the language on 3.6F instruction, and it's going to be very long. I read it yesterday. I'm going to sustain it in part and allow you or to address the battered women and spouse. I think 3.6F was like something about self-defense or something. 3.6F, Florida. Oh, yes. Justifiable use of deadly force. Florida Supreme... Oh, my God. This is 15 pages. I'm not going to read the whole thing, but let's read a portion of it. 3.6F, justifiable use of deadly force. Because there are many defenses applicable to deadly force, self-defense, give only those parts of instructions that are required by the evidence. Deadly force means force likely to cause death or great bodily harm. What the hell? Why is this document all like fucked up looking? Is this like someone's notes or something? Anyways, that's what 3.6F is. The document has a lot of crossouts and other shit, so I don't know. We're not gonna read that. We good. 3.6F. All right, next bench. What do we got here? Ooh, this might be a long one. Question. Now, I want to go back just a second. We talked about the subjective nature of the abused individual's understanding of what's happening. Does this subjective or does experience that they have suffered result in, on occasion, their experience and their anticipation or assuming or imagining a threat that others may not? Answer. Yes, sir. Mr. J. Objection. May we approach? Court. Yes. All right. Yes, sir. Mr. J. Under the case law that I cited, and I can't name the case offhand without stopping and reading it, but this is exactly what is not allowed for PTSD. It's not allowed to come in to show why somebody is subjectively making somebody act differently than the ordinary, objectively reasonable person. What this evidence comes in is, like he explained earlier, to show that it's objectively reasonable to do things like leave. I mean, refuse to flee or flee. What's not allowed is, well, I think in Vietnam, well, I was in Vietnam. Okay, what's not allowed is, well, I think I was in Vietnam and now fireworks scare me. Makes me think it's gunshot. And that's why I heard fireworks. I went outside. I shot my gun everywhere. So that's a position that this is legally not relevant under what PTSD battered spouse can be used for. Response. Or garbage cans. Or that. Or garbage cans. Response. Mr. Beck. Your Honor, I'm fine. Essentially, I'm parroting with a deposition that was taken by Dr. Brandon and by the state. So this is deemed to be an appropriate statement. I can move on. All right. Next bench. What do we have here? Question. In this instance, this particular matter regarding the state v. Sarah Boone, were you approached about the possibility of doing an assessment as to Sarah Boone? Mr. J. Objection. Relevance. The court. Approach. At the bench. The court. My understanding is that he's not rendering any other opinions. Mr. Beck. Right. The court. So what does whether or not he was approached? Mr. Beck, I believe the fact that he did not believe that there was an adequate time given the 30 days that were available to do an appropriate assessment of the patient. In this instance, Sarah Boone. So it's going to be utilized by the defense to establish that expert testimony of Dr. Harper should be deemed more reliable than the testimony of somebody who has only appeared one time in a series of tests and has done nothing more. The court. Anything further? Mr. J. I think it's relevant, that he's approached and declined. And then also I'm going to preemptively object to that since the rules only allow my expert to evaluate her once. The court. All right, I'm going to sustain the objection. Not as to the second portion, but, as to the first. The fact that he asked and couldn't do it within 30 days isn't relevant to any opinion that he's offering. Mr. Owens. Wait, why is Mr. Owens here? Mr. Owens. He's allowed to express what is necessary for him in his own professional opinion. To express an opinion, what he would need, what data he would need, what assessment, how many times, how much he would need before he could give his professional opinion. I think he can testify about that. I would need several sessions with a client. Mr. Owens is funny. The court. But that's not the question that's being asked. The question that's being asked right now is you were approached to serve as an expert and opine specifically as it relates to Ms. Boone. I mean, that's my takeaway from the question. Mr. Beck. I can rephrase the question. The court. So, I mean, if you want to go to that way, that's a different kitty. That's not what before me is right now. Is different kitty, is that like a Florida phrase, term or something like that? I've never heard that phrase being used ever. When I think of kitty, I think of like the meow sense, Mr. Beck. I'll rephrase the question. The court. Okay. The objection is sustained. Mr. J. I would object under local administrative order that there's only supposed to be one lawyer per witness, and now I'm combating two lawyers. That's right. I was like, why is Mr. Owens up in here? The court. So, I mean, general rules is it's one voice. So whoever's going to be directing that witness, I need to hear for evidentiary response moving forward. Mr. Beck. That's fine. Thank you. The court. Okay. I'm going to sustain the objection, but you can rephrase it. The court. Judge, Mr. Owens. Judge, The court. Mr. Owens, I can't. This is Mr. Beck's witness. Mr. Owens, I understand, but Mr. Owens, this is Mr. Beck's witness. Thank you. Oh, Mr. Owens got shut down. All right, what's next here? Question. I understand your answers today. I'm not saying that they were different the other day, but I do understand that you say it's very important to do a comprehensive evaluation to get a full picture of what is going on in the perceived battered spouse's mind. Correct. Mr. Beck, Your Honor, may we approach? Yes, at the bench. Legal grounds of the objection, Your Honor. I object on the grounds that this is a very area that the state objected to for us going into. I want to ask whether or not the court's opinion of whether or not they've, in fact, opened the door as to the nature of the type of work that he would do and his inability to do it in this case because he was not afforded the time or the opportunity. So I think the state has opened the door. The response, Mr. J. I'm not going anywhere near asking him why he didn't do it. He went into great detail about why it's important to assess the credibility of all the evidence. The court. Didn't you talk about the collateral sources in 911 calls and witness statements? Mr. Beck, in a general context, not a specific context, as the state is attempting to do here, and because they are essentially positing these questions in a hypothetical phrase, they, I believe, have opined the door for have opined. Let me start over. Because they are essentially positing these questions in a hypothetical phrase, say, I believe, have opened the door for being able to describe that this individual was contacted and identified, that he could, gets cut off, the court. That's not my takeaway from the state's question. The state's question was, you want to have a comprehensive review? Is that what he talked about? Is what he talked about in direct? Mr. Beck. Okay, I just want to ask the question whether or not he could accomplish that review in the time that was afforded to him, and why did he not? The court. As to opening the door, I don't see it because he specifically testified on direct as to what one would be looking for as for rendering an opinion. And certainly that's fodder for cross-examination. Mr. Beck, sure. The court. Now, I'm not going to say it right now and foreclose the opening the door. Let's see where Mr. J's questions go. And I do find it fair game for cross-examination. Which expert is this? Is this Brennan or is this Brennan? I see some Dunkin' Donuts in here. Cross-examination, Dr. I think it's Dr. Brennan, maybe. I think it's Dr. Brennan. All right, next. Sip of water first.